Yes.
Respectfully, my lord.
Yes.
O.O. Eban,
Yes.
State Council 1. My lord,
Yes.
my appearance is for the 1st to 5th and 8th to 10th defendant.
Yes. This matter is for judgment. The judgment
As the court pleases.
is ready. The claimant by the general form of complaint dated 11th day of April 2019 commenced this suit against the defendants. In the process, the claimant amended his complaint and the defendant also amended their defense. This matter is put based on the amended processes before the court. I have reproduced the 16 reliefs being sought by the claimant in the body of the judgment, so I will skip reading those reliefs. I have also captured the case of the claimant. I have also captured the case of the defendant, as well as the submission of the defendants based on the two issues formulated. I have equally captured the submissions of the claimant based on the 14 issues formulated for determination. In the circumstances, I will not, in view of time, I will not be reading the preliminaries, so I will go straight to the decision of the court. I have taken time to calmly read through the facts and evidence adduced by the parties before the court. By the parties before the court. I have also taken time to scrutinize the several documents tendered and admitted in evidence before the court. I have also considered the enlightening and weighty submissions of learned counsel for the parties, carefully noting several decided cases relied upon by them. However, let me say here that some of the cases cited by counsel were wrongly, the citation were wrongly stated. Some decisions of the Court of Appeal were tagged as decisions of the Supreme Court, and even decision of this court was tagged as decision of the Court of Appeal. This will serve as a reminder for counsel to always be circumspect when citing authorities before the court. In the final written address of the defendant, twin issues were formulated for resolution, while the counsel for the claimant submitted 14 issues for resolution. While submitted 14 issues. Please, we are in court. There should be no noise. I'm hearing noise from the background. Please, there should be no noise. We are in court. The reliefs have been reproduced in the earlier part of this judgment. There are 60 reliefs being sought by the claimant. Reliefs 1, 2, 3, 4, 14, and 15 are for declarations. reliefs 5, 6, 7, 8, 9, 10, 11, 12, and 13 and 16 are for payment of unpaid salaries, ratau allowance, refund of salary collected by 10th dependent, compensation for breach of contracts, exemplary damages, and interest on the judgment sum. There is also the relief claiming salary for 3 years, and independent relief claiming for salary for 3 years at the sum of 500,000 naira per month. There is also claim for 25 million naira as medical expenses, 5 million as cost of litigation, and 15 million as interest on loans secured by the claimant. Before delving into determination of the substantive suit, it behoves on this court to first and foremost start resolving the preliminary issue raised by the defendant. This on the ground that this suit is statute bar, as it is presently constituted or caught by the provisions of Section 2A of the Public Officers Protection Act, which has rendered the suit to be incompetent and liable to be dismissed, and the right to relief or to ventilate the grievances has been taken away by the delay in filing of this suit within the 3 months of accrual of course of action in 2014. The claimant on his part has argued that this suit was not affected by limitation law and the injury is continuous, and that has brought this suit within the exception to the rule. The claimant also argued that apart from continuance of injury or damage, there is bad faith, malice, abuse of office, fraudulent concealment, contract of employment, and discrimination among others. It was argued that all this cannot give cover to a public officer who violated the law. The defendants, through their counsel in arguing the objection, relied on Section 2A of the Public Officers Protection Act. Let me say here that reliance on Section 2A of the Public Officers Protection Act was wrong in this case. The act was meant to provide protection for federal public officers in the performance of their lawful duties. It does not govern the parties in this case, who are state actors and not having anything to do with federal government. The state has its own law, which is immaterial with Section 2A of the Public Officers Protection Act, and it is the Cross River State Public Officers Protection Law which applies to the parties in this case. In the circumstances, I shall be using the state law in determining the objection, because the provisions are similar to that of Section 2A of the Public Officers Protection Act. It is clear. I have also reproduced the provision of Section 1A. It is clear that Section 1A of the Cross River State Public Officers Protection Law, as amended, requires filing of an action against a public officer or public officers to which the section applies, or to whom the section meant to protect, within a period of 6 months within the accrual of the course of action or complaint or the complaint thereof. From the pleadings and evidence before the court, the claimant was by the exhibit C4 employed by the first defendant with effect from 8th of August 1988 as an account clerk. The first defendant, by the letter dated 9th of October 1990, confirmed the appointment of the claimant with effect from 8th of August 1990. See Exhibit C5. According to the claimant, he was paid last in May 2014. Thereafter, his salary ceased. The reason given by the defendant for stoppage of claimant's salary was that his failure to attend audit verification exercise meant to detect ghost workers and his refusal to obey local directives for his deployment to secondary school education board as a teacher. The claimant instituted this suit on the 11th day of April 2019 from 18th from from 18th of June 2014 when his salary was last paid to April 2019 is a period of about 5 years now. This means that this action was instituted beyond the six-month period required by Section 1A of the Cross River State Public Officers Protection Law. In his answers to the charge of this case being started bar, the claimant stated that this suit is not statute bar as it is saved by continuance of injury, which is one of the exceptions provided in the law. The provisions of Section 1A of the Public Officers Protection Act Protection Law constitute a limitation law which the legislature designated it to provide protection for public officers, corporate or incorporated bodies from debt detraction in the conduct of their discharge of their official duties or assignment by litigant that might have become odiously by litigation that might have become odiously or in which witnesses may no longer be available or may not reasonably be gotten to testify due to time lag. See the case of Boche versus Ogoja local government area. The object of the provisions is therefore to afford protection to public officers in respect of anything done in the discharge of their official duties or in the course of carrying out their duty. The protection comes into play after the expiration of 6 months from the date of the accrual of the course of action or neglect or default complaint of which give rise to the course of action. See the case of Yabuge versus Commissioner of Police. See also Egbe versus Ade Farasi. See also Egbe versus Alhaji. See also Ekyabu versus Egyabu versus Adiri. It is quite clear that the general effect of Section 1 of the Cross River State Public Officers Protection Law, like Section 2A of the Public Officers Protection Act, is that there where any action is started by a party who might otherwise have had a course of action loses right to enforce it by judicial process because the period of time prescribed by the limitation law for instituting such an action has elapsed. Thus, in an action commenced after expiration of the period which an action must be brought as stipulated in a statute of limitation is not maintainable. See the case of a boy Bay versus NNPC. See also Ibrahim versus Alhaji Madugu Lawal and others. See also Egbe Adepa Hassan Sufra. See also Padere versus Oyo State. See also Attorney General Adama State versus Attorney General of the Federation. See also Obiafuna versus Okoi. However, it is pertinent to note, as argued by the claimant, that the general rule laid down, like every other general rule, is not without exception. Though an action against a public officer in respect of any act done in pursuance or execution of act or law or public duty default, same can be commenced within 6 months next after the act. Neglect or default complaint of the situation is not the same in a case of continuance of damages or injury, in which case the person agreed must institute the action within 6 months next after cessation of the damage or injury complaint of. See the case of Central Bank of Nigeria versus Jacob Ade Oladele Amao. In the case at hand, counsel for the defendant maintained that the claimant's action is covered by the provisions of the limitation law, while the position of the counsel for the claimant is that the act being complained of by the defendant is that of continuance of damage or injury which is yet to abate. To buttress his argument, claimant relied on the case of Attorney General State versus Attorney General of Bayelsa State. Relying on the case, counsel for the respondent maintained that this action falls within the exception provided. It was also argued that the acts complained of was in bad faith, malice, and abuse of office. It was further argued that public officers protection law does not apply to contract of employment. It can be deduced from the submissions of counsel for the claimant that it considered that the present action was not instituted within 6 months from the date of the act, neglect or default complaint of. This has narrowed down the issue for consideration in this objection. The case of the claimant is that the case is covered by issue of continuance of damage or injury, in which case protection or cover provided for public officers can only come within the ambit of Section 1A of the Public Officers Protection Law if the action was brought within 6 months after the cessation or continuance of the damage or injury. The apex court, the apex court of the land in interpreting the phrase continuance of damages or injury, interpreted continuance of damages or injury to mean continuance or repeat of the act which caused the injury. It does not and cannot be said to mean the concomitant effect of the damage or injury. See the case of INEC versus Ogbadibo local government area and others. In view of the definition of phrase continuance of damage or injury as provided for by the Supreme Court, the question to be asked is, does the act complained of in this suit of continuous damage or injury? Since this suit was commenced by their complaint, from the pleadings and evidence, it can be gleaned that what it regards filing of this suit is the stoppage of claimant's salary on 18th day of June 2014. According to the claimant, from 18th day of June 2014, when his suit was when his last salary was paid to the time of filing of this suit on 11th day of April 2014, the defendants have ceased to pay his salary. The claimant has also stated that he was neither terminated nor dismissed from service. This goes to show continuance of damage or injury respecting monthly salary which continues This goes to show continuance of damage or injury respecting monthly salary, which continues to accrue on monthly basis. In view of the above finding, the case of the claimant is not statute barred, as it is well within the recognized exception to the application of Section 1A of the Public Officers Protection Law. The next preliminary issue to be considered is the argument canvassed by counsel for the claimant on whether this court has jurisdiction to countenance any process, particularly the first to fifth, eighth to 10th defendants and amended statement of defense filed on the 17th day of January 2026 and final written address filed on the 16th day of March 2026, which oh, particularly first to fifth and eighth to 10th defendant amended statement of defense filed on the 17th day of January 2026, and the final written address filed on the 16th day of March 2026, who were foreclosed by the order of this court made on 10th day of December 2020 without setting aside the foreclosure order. Counsel insisted that this court is divested of jurisdiction bias to countenance the defense and final written address of the defendants on ground of foreclosure order. Divested, this court is divested of jurisdiction of bias to countenance the defense and final written address filed by the defendant on ground of foreclosure. From the record of this court, this suit was commenced before Honorable Justice M.N. Esowe when she was in Calabar Division. This case is now among the numerous cases I inherited when I assumed duty in the Calabar Division. Consequently, hearing in the matter started de novo. Therefore, I do not see how foreclosure order made in inconclusive proceeding will affect steps taken when the suit started de novo. The leave granted by the court for Therefore, I do not see how foreclosure order made in an inconclusive proceedings will affect steps taken when the suit started de novo. The leave granted by the court for regularization of defendants' processes was in order, and the court has requisite bias to grant same. The claimant quarrel with the defendant's defense and address has no basis to stand. The objection is hereby discountenanced. What is even
As the court
surprising is
pleases.
that this objection it was not raised when the defendant applied to regularize their process. The claimant waited until address stage to raise the objection. The claimant, by raising the objection, by not raising the objection timely, has waived his right to object, since the objection is procedural and not on substantive law. See the case of Alao. Also, by raising the objection at this stage, the claimant resorted to springing surprises. The claimant has also raised objection to the defendant's statement of defense filed on 19th day of January 2026 on the ground that the state defense was signed and dated on 19th of day of January 2025. The claimant further faulted the said defense in that he let me say the requirement to sign is that of the statement of defense having been signed, the non-signing of witness statement on the non-signing of list of witnesses and list of documents does not have any effect on the validity of the said document. Furthermore, the objection is being belatedly raised in the circumstances I hereby discountenance it. The claimant has also argued that granting or withdrawal of application for extension of time by the court and striking out motion on notice made by the court has become functus officios in respect of the subsequent application for extension of time. On 17th day of February 2026, the counsel for the defendant allowed to withdraw motion on notice for extension of time filed on the 20th day of January 2026. The said motion was struck out as the claimant did not object to it. The counsel for the defendant then applied orally for extension of time to file defense out of time. The application was granted. I do not understand why the defendant did not object to the oral application and waited until now when the matter is at address stage. This clearly shows that the objection of counsel is vexatious and lack merit. It is thereby dismissed. I quite agree with counsel for the defendant that objection of the claimant to their defense at this stage, as the address stage, is a clear use of technicality to scuttle justice. I refuse to be dragged into such an arena. Having disposed of the preliminary objection, I shall now proceed to consider the claim of the claimant as to see whether the claimant has proved entitlement to any of the relief sought before the court. Coming to the determination of the claim before the court, it has been established by a long line of decided cases that the burden of proof in civil cases, like the case at hand, rests always Therefore, the burden is on the claimant in the instant case to prove that he is entitled to the relief sought. It is when claimant has adduced sufficient, cogent, credible, and admissible evidence establishing his claim that the burden shifts to the defendant. This is because burden of proof in civil cases or matters is not static and may shift in the course of proceeding in a case, depending on the state of pleading and at various stages. The initial evidential burden of introducing evidence to prove a claim of legal right liability based on assertions of fact upon which right or liability is claimed is placed on the claimant and until it is discharged on the balance of probability of preponderance of evidence as required under Section 134 of the Evidence Act. In this case, the claimant is the one that desired this court to enter judgment in his favor on the various sums of money and other declaratory reliefs he sought. Therefore, reliefs 5, 6, 7, 8, 9, 10, 13, and 16. These are claims for special damages. Therefore, the claimant have the initial evidential value. Evidential burden of proving the fact he asserted on which he based his claim if judgment is to be entered in his favor. See the case of Adegoke versus Adibi, see Agu versus Inaji, see also Onuma versus Ezeokole, and a host of other cases cited therein. What emerges from the above decisions is that burden of proof in civil cases is of two types. The first, which is the legal burden, is the ability of a claimant asserting positively to establish and prove the entire result to entire establish and prove the entire or reasonable portion of his case before a court of law that before a court of law can give judgment in his favor. This is always constantly on the claimant. The other type is related to the particular facts or issue which a party claims exist. It is the burden of proof that oscillate from one party to another, while the type of burden of proof is this type of burden of proof is legal burden or burden of establishing a case. The second is called evidential burden. See the case of Oguele versus Ampa Agutu, Cooperative Group Farming Society Nigeria versus Nigerian Agricultural and Cooperative Banks. From the reliefs being sought by the claimant, the monetary relief falls within what is called special damages, in which the law requires it to be specially pleaded, particularized, and strictly proved. Where a party claims special damages, the burden is on him to prove special damages by leading credible evidence, most of the time by documentary evidence, to show actual loss he suffered. Furthermore, unchallenged, if the deficit of evidence is not enough to prove special damages, where the claim is required to be proved by documentary evidence. See the case of ATE and Co Limited versus military governor of Ogun State. See also UBN versus Wanko. This means that special damages are such as the law would not infer from the nature of the act because they are exceptional in their character and must be claimed specially and posed that special damages are such damages suffered by a claimant that is quantifiable in money worth. A damage is special in the sense that it is easily discernible and quantifiable. It should not rest on the plural conception or notions that would give rise to speculation, approximation, or estimate. In other words, when it comes to special damages, all the losses claimed on every item must have crystallized in terms and value before the trial court. See Shoddy Paper and Co versus Daily Times. The Supreme Court has provided a guide as to what strict proof means when it comes to the issue of proof of special damages. This was in the case of Onyiro versus Onyiro, where it was stated thus: strict proof does not imply unusual proof, rather it is testimony in determining a case. The court is enjoined by law to restrict its consideration to the reliefs contained in the claim. Put it differently, the court has no power to deviate from or justifying the claim of the claimant as adumbrated by the reliefs. In other words, the claim is determined by the reliefs being sought. See a Gabriel Atibi versus Camel Metal, where it was held a claim is circumscribed by the relief sought. The duty of plaintiff stroke claimant is to pay only reliefs claim. It cannot grant relief not claimed. Aligned with the above dictum, this court in determining the case of the claimant will be guided by the reliefs being sought. In the circumstances, I shall now consider relief sought by the claimant vis-à-vis the evidence adduced before the court so as to see whether claimant has justified granting of any of the reliefs. I shall now consider reliefs 5, 6, 7, 8, 9, 10, 11, and 16. These reliefs are seeking for monetary retirement, entitlement ranging from payment of arrears of salaries, allowances, compensation, as pointed out earlier. These reliefs, being monetary in nature, are termed as special damages, which in law must be specially pleaded, particularized, and strictly proved. As pointed out earlier, these reliefs, being monetary in nature, are what in law term as special damages, which law which must be specifically pleaded, particularized, and strictly proved by the claimant. See 7 Up Bottling Company, Nigeria Limited versus Augustus. See also NNPC versus Clifford. Clifford. The claimant has stated that his salary was stopped in June 2014. As pointed out earlier, for a claim in special damages to succeed, it must be pleaded and proved strictly, and the court is not entitled to make its own estimation on such issue. The rule that special damages, unlike general damages, must be strictly proved is well founded in law. What the rule requires is, in effect, is that anyone making a claim in special damages must prove strictly that he is entitled to. The important thing is that the evidence proffered must be qualitative and credible, and such as lead to the quantification. Each case depends on its own facts, circumstances. These are cases where it will be impossible to pass the test required unless documentary proof is produced to prove entitlement. In other words, oral evidence which is credible may be sufficient. The character of the evidence called must measure up to the circumstances of the occasion and exception. CSPDC Nigeria Limited versus Table. Now, the question that need to be resolved is, has the claimant, by evidence adduced before the court, been able to prove entitlement to any of the monetary reliefs being sought, as unpaid salaries, retire allowances, general and in an attempt to prove his claim, the claimant relied on Exhibit C1, C2, C3, C4, C5, C6, C7, C8, C9, C10, C11, C12, and C13, as well as the oral testimony. The defendant in their reaction have stated that the defendant in their reaction have stated that the exhibit tendered cannot prove monetary claim of the claimant, as the claimant has omitted his full statement of account covering the period of claim. I have appraised the evidence adduced by the parties on the various claims by the claimant. From the evidence before the court, the claimant's salary was paid last on 18th of June 2014. Payment of his May salary, see Exhibit C2. Access Bank Statement of Account. The defendant are not disputing stoppage of salary. Their defense was that claimant's salary was stopped because he failed to attend audit verification conducted fish out ghost workers. Refusal to report to his new duty post as per his deployment on XBC 14, and also attending standing schools without approval. The claimant has debunked the assertions of the defendant. The defendant, in attempt to debunk the assertion of the claimant, maintained that he is under employment of the first defendant as his employment is still subsisting. The claimant has, in his evidence under cross-examination, stated that when his salary was stopped, he went to meet the first defendant and he was told it was because he had not been he has not attended verification. That's why his salary was stopped. And the claimant further stated that he approached first defendant but refused to verify him as he was not given the clearance letter. For Exhibit C8 and C9, there are not evidence to show claimant was paid for those months. For claim of April 2009, February to April 2009, the claimant has not adduced any convincing evidence to show that he was not paid salary for those months, as Exhibit C2 covers only 1st to 30th June 2014. The claimant has not tendered his statement of account covering the period for the months in which he allegedly was not paid. This failure is enough to disentitle the claimant to reliefs 5 and 6, as he has failed to discharge the burden on him, the burden of proof on him, and shift the burden to the defendant. On relief 6, which is for unpaid salaries for 112 months from June 2014 to April 2019, when this suit was instituted, Exhibit C2 shows that the last salary the defendant was paid was in May 2014. This has not been disputed, but the defense of the defendant is that claimant failed to attend audit verification. That's why his name was automatically excluded from the payroll, and he has refused to go and do the verification. But the claimant stated that when his salary was stopped, he went to the first defendant to complain, and he was told the stoppage of his salary was because he did not attend audit verification. From the evidence before the court, the claimant deployment to secondary school education board as a classroom teacher was, as per Exhibit C14, made on the 23rd day of February 2005. The claimant has stated that he never requested for any deployment or transfer or secondment from his present employer to secondary school education board. It is clear to me that Exhibit C4 supports the position of the claimant that he never requested or for deployment or transfer to secondary school education board as a classroom teacher. The defendants have argued that refusal of claimant to report as per Exhibit C14 is this. Exhibit C14 supported the position of the claimant that he never requested for deployment or transfer to secondary education board as a classroom teacher. The dependents have argued that the refusal of the claimant to report as per Exhibit C14 is disobedience of lawful orders. I beg to disagree with the position of the defendants. The claimant was employed by the first defendant as per Exhibit C4, which was which was as a result of an exercise done pursuant to Section 23 of the Broadcasting Corporation Law, Cap B3 Laws of Cross River State 2004. This means the claimant is a bona fide employee of the first defendant, and the first defendant has power over the claimant to deploy him, but within the first defendant organization. In the case at hand, it was not first defendant that even deployed the claimant. It was Secondary Education Board, an alien to the contract between the claimant and the first defendant, that purportedly deployed the claimant without his consent or permission. Therefore, the defendants cannot, with all sense of decency, say that the claimant disobeyed lawful orders. Even under the public service rules, for an employee to be deployed, it has to be within his organization. If an employee is to be posted or transferred to another agency of government different from his agency, it must be with the consent of the employee, and it cannot be unilateral as it was done in this case. The claimant's employment being governed by public service rules, as parties have alluded, and due to the absence of rules or regulation made by the Board of First Defendant pursuant to Section 37A and B of Cap B3 Laws of Cross River State, the claimant's employment is one less with statutory labor. To crown it all, the Court of Appeal in the case of Achu versus Civil Service of Cross River State has held that by the preface to the Cross River State Public Service Rules, it provides that the rules apply to all public servants, which means the rules apply both to civil and public servants. Thus, there is no difference between the public servant and a civil servant. See the case of Eze versus Okechukwu. Since the claimant's employment is governed by public service rules, any action to be taken by the defendants regarding claimant's employment subject must be in conformity with the public service rules. In this wise, the action of the Secondary School Education Board in deploying the claimant is ultra vires and null and void and of no effect, as it is a clear usurpation of the function of the second defendant, the Civil Service Commission of Cross River State, that has the power to promote, transfer posts, or deploy public officers like the claimant to any government agency or parastatal, and even in that respect, it has to be in line with the rules as provided by the regulation. Therefore, the deployment of the claimant from Cross River State Broadcasting Corporation to Secondary Education Board as per Exhibit C14 is hereby declared unlawful, null and void. The claimant was employed by the first defendant, a specific statutory corporation, which possesses a distinct legal personality, moving the claimant from a broadcasting environment to a classroom as a teacher without his consent and without adhering to the formal procedure for transfer of service or secondment as prescribed by law, constitute a fundamental breach of the contract of employment. Such an Such an administrative action is an arbitrary exercise of power. The defendants failed to demonstrate that the Cross River State Public Service rules authorize the unilateral and the cross cadre deployment of staff. In employment with statutory labor, the procedure for transfer, secondment, or deployment must be strictly adhered to. The legal test is whether the deployment constituted a unilateral vitiation of the fundamental sum of employment contract. Under the Cross River State Public Service rules, transfer must generally be within similar cadre of grade. Moving claimant from broadcasting sector to a teaching role is a different board. In a different board is an unlawful deployment. The case of Longe versus First Bank of Nigeria PLC emphasized that where employment is protected by statute, any administrative action contrary to the enabling rules is null and void and of no effect. Also, the case of Oloruntoba Oju versus Abdurrahim mandates that the action taken by statutory authorities must strictly comply with the enabling law, and rules. The Cross River State Public Service Rules 2004 govern the conduct of movement of public servants, but they do not grant defendants the power to unilaterally vary the employment by moving employee between statutory bodies under Nigerian law. An employee of a statutory body like the claimant cannot be treated as a floating civil servant. The case of Shitabe versus Federal Public Service Commission reinforces that where an employment is protected by statute, any move to alter the terms of that employment must follow the due process laid down in the relevant regulation, which was not done in this case. On the claim for unpaid arrears of salaries in employment matters, the right to salary is generally linked to performance of duties. See Honica Sawmill versus Hoff, where, however, the circumstances surrounding employment in the case at hand, the claimant absence from duty in the case at hand, can the claimant's absence from duty be said to be the direct result of unlawful transfer made without due process in violation of established public service rules? From the evidence on record, claimant's salary was stopped as a result of failure to attend audit verification. It is important where a worker failed to attend verification, his salary can be stopped temporarily for failing to attend audit verification. This is done because the worker's failure to appear create an administrative presumption that he might be a ghost worker or have However, stopping salary cannot be used as a permanent punishment or backdoor dismissal. It is meant to be a temporary lever to force the employee to come forward for verification. Once employee salary is stopped, the relevant government agency cannot sit idle without doing more. The law dictates that they must immediately activate disciplinary machinery under which Public Service Rules under Public Service Rules 2004 by issuing a formal query detailing the worker's absence from duty, provides the worker with opportunity to respond. Fair hearing formally indicated so the work provide provide the worker with an opportunity to respond, formally interdict the worker on half salary it is if he was found to be fraudulent, or formally terminate the employment if he failed to exculpate himself by freezing a salary indefinitely without issuing a query or initiating disciplinary panel. The first defendant has committed an administrative illegality. This is because public servants are protected by public service rules. Their employment has statutory labor. This means their employment cannot be altered or affected except in strict adherence to the written rules. Since the agency failed to follow the procedure, no query, no panel, no termination, no dismissal, the worker employment may be considered to be legally in existence because the first dependent left the worker in limbo filing, without formally firing him or giving him query. The worker remains a legal employee of the state. However, in line with the case at hand, there is a new dimension which was introduced as the claimant insisted that the claimant immediately after his salary was stopped in 2014 went to law school for his BL without approval or leave. However, in the case at hand, the dimension the dimension introduced is that the defendant after stoppage of his salary in 2014 went to law school on full-time basis without approval or leave of absence. The claimant has admitted going to law school without taking permission from the defendant. The claimant's action amount to abscondment from duty for going to law school without taking permission or applying for leave of absence. The reply it is also evident that the claimant has studied law at the University of Calabar without informing his employer and without taking permission. His response to going to University of Calabar was that he does not need any approval as the LLB program he is pursuing was part-time. This assertion cannot be true because in Nigeria, law degree is on full-time basis, not on part-time, as part-time law degree is not recognized or accepted for purposes of admission into the Nigerian law school. The issue The issue of part-time or full-time is within the personal knowledge of the claimant and has bounden duty to prove by tendering his letter of admission or any other evidence. But claimant did not do that. In view of in view of in view of this, I quite agree that the dependent, as even before his purported deployment, as per XBC 14, not been attending his duty, but the dependent condoned his misconduct for not taking any disciplinary action against him. From the evidence before me, XBC 14, the claimant's deployment was made in 2005, and his salary continues to run unabated until 2014, when it was stopped for the claimant's non-participation at audit verification to flush out ghost workers. From 2005, when the claimant was deployed, to 2014, when the salary was stopped, it was to further support this view. The claimant pursued LLB program at University of Calabar, which he alleged was part-time program. The claimant after also stated that he attended law school Abuja campus for his BL on full-time basis and was called to the bar in 2015. It is also of common knowledge that apart from National Open University of Nigeria, which is permitted to run part-time law program, there is no other university that is allowed to run part-time law program in Nigeria. What all this show is that the claimant's salary wouldn't have been stopped if not because of audit verification. In view of all I have said above and the analysis of the fact as presented to the court, I have no hesitation in coming to the conclusion that the claimant accepted himself to study law and went to law school without permission. I also come to the conclusion that the claimant absence was not as a result of alleged deployment. The claimant's conduct is going to university University of Calabar and law school without permission of the first dependent clearly shows that he was not ready to work. This also serve as a cloak to his claim for unpaid arrears of salary. The claimant failed to prove entitlement to his unpaid salaries. His admission that he went to law school and called to the bar without approval of the defendant and staying away from his duty after call to bar and engaging in private legal practice has shown that he has constructively dismissed himself as asserted by the defendant from service of the defendant. See the case of Obo versus Commissioner of Education, Bendel State. See also the case of Dongotoy versus Civil Service Commission of Plateau State. See also Lasisi versus Allied Bank of Nigeria Limited, where the admissions where the admission of the claimant in this case is admission against interest. With this finding, all his claim of salaries are hereby all claims all the claims on salaries are not grantable, and same are hereby refused. In addition, his evidence before the court has shown that the claimant has not proved entitlement to his salary by strict proof required of special damages. The reason being that the last salary paid to claimant as per Exhibit C2 was the sum of 64,000 naira, but his pleadings and evidence before the court, he is claiming different amount, contrary to what is contained in Exhibit C2, and he has not shown that after payment on Exhibit C2, he was promoted or his salary was altered and increased. It is also clear from his graduation in 2006 to 2014 when his salary was stopped and when he went to law school, he had been collecting his salary. This also supports the fact that his absence from duty is not attributable to stoppage of his salary, as he had been pursuing low degree program. This also brings us to relief 10, claim of 500 million naira as compensation for loss of seniority. The claimant whose salary was stopped in 2014 and when the claimant whose salary was stopped in 2014 and went to law school in 2014 and was called to the bar in 2015 cannot be right to say that dependent caused him to lose seniority at the bar. As rightly argued by the counsel for the defendant, seniority at the bar is determined by the date of call to the bar and not by graduation. Therefore, the purported delay that caused the claimants not to attend law school was his own making. The defendant cannot be blamed for that. Even if the delay was caused by the defendant, the claimant has not established any right for the defendant to allow him to pursue university degree and law school while in service. Therefore, relief 10 failed, same is hereby refused. At this juncture, I shall also consider relief 7 claim for retire allowances in the sum of 25,840,000 naira. In labor jurisprudence, for claim for allowances to be granted, the claimant must establish his entitlement to the allowance. This is done by showing or referring to the instrument of provisions of conditions of service that it granted the said allowances to the employee, failing which such allowance cannot be granted. In this case, the claimant has not referred the court to any provisions of the public service rules or any regulation or instrument granting entitlement to retire allowance to employees of the first defendant. In view of this, all members of retire. In view of this, Relief 7 claiming retire allowance failed, same is hereby refused. Furthermore, the claimant has not even tendered any evidence to show that he has at one time enjoyed the said allowance. Relief 8 is for refund of salary allegedly stated to have been illegally collected from 1st of January 1998 to August 2023. The claimant has bounden duty to prove the said salaries, the illegality, and that they were actually collected to 10th defendant who was not entitled to it. Apart from mere assertion, there is no iota of evidence to prove this relief, the claimant has not adduced any evidence of collection of those alleged collection of the alleged salary by the 10th defendant. In the circumstances and in the absence of any proof, relief 10 is not granted full sum is hereby refused. Furthermore, his claim, this is this claim is said to be for the defendant that the, the money to be recovered or to be refunded by the 10th defendant is to be is for the fourth defendant. I do not know where the claimant derives the authority or right to make such a claim for a party that is already before the court in the same suit where the party is a defendant. The claimant does not have locus to make this claim. Same is hereby refused. Relief 9 is for 1 billion naira breach of contract. A claim for compensation for breach of contract can only arise where the party succeeded in establishing the breach before the court. The claimant has not been able to establish that there was any breach of his contract of employment as he is the architect of his own predicament. Relief. This relief fell, same is hereby refused. Relief 11 is for the sum of 40 million as exemplary damages. There is no any evidence or proof of this entitlement of this relief. Counsel has failed to adduce evidence to establish entitlement to exemplary damages. In the circumstances, the relief failed and same is refused. Or relief 12, which is for 5 million cost of litigation. The law is now well settled that cost is granted at the discretion of the court based on proof of what was actually spent in prosecuting the matter. The cost awarded relates to money spent on filing of processes and other sundry expenses. It does not extend to payment of solicitor's fee, as the claimant want the court to believe by tendering receipts evidencing payment to his lawyers. Cost is awarded to a successful party to assuage expenses in court. In the case at hand, since there is no success, there is no cost to be awarded in favor of the claimant. Relief 13 is for interest at 20% post-judgment interest. This relief is also granted at the discretion of the court, and it is not the employee that can state the percentage for which the court should award. It is at the discretion of the court. Relief 14 is for declaration that claimant is entitled to be paid retirement as to be paid entitlement of retired permanent secretary effective August 2023. And relief 15 is for claimant to be given a brand new Hilux as parting gift, as it was given to his colleagues who have retired as permanent secretaries. There is no evidence adduced by the claimant to show or establish entitlement for him to be appointed as permanent secretary In fact, the law the appointment of permanent secretary is not an entitlement. It is a discretionary appointment made by the governor of the state as constitutionally granted the power to him as per section 208 of the Constitution of the Federal Republic of Nigeria 1999 as amended. And for the brand new Kellogg's, the claimant has not referred this court to any provision of the public service rules that entitle him to be, or circular of government that entitle him to be given a brand new Kellogg's. And the claimant is qualified to be allocated one. In the absence of evidence in proof, the claimant willfully failed to prove entitlement to be appointed as permanent secretary and also to be given a brand new Hilux. These reliefs fail, same are hereby refused. Then comes the claims for 500,000 naira salary per month from 1st January 2020 to December 2022. That is making salary for 3 years, which comes to the sum of 18 million naira. This is a claim for special damages requiring particularization and strict proof. There was no evidence adduced by the claimant to prove entitlement to these reliefs. The claimant has also not produced any evidence, has not adduced any evidence to show that he has been promoted to the rank of director or to the rank of permanent secretary, entitling him to be paid 500,000 naira per month. In the circumstances, the state relief is speculative, and no, as the claimant has not adduced any evidence to prove same, it fails and same is hereby refused. The claimant has also made a claim of 25 million naira as medical expenses. I have reviewed the evidence and submissions of counsel on this. It is clear that there is no clear evidence to show that the injury for which the claimant was said to have been treated at the hospital was as a result of the actions of the defendant, and the accident cannot, which led to the claimant being admitted and treated, cannot be said to be in the course of his official duties, as this court has found that he has already abandoned his duty since 2014 and went to law school, and when he graduated and called to the bar, he refused to report back to the office to continue his work, which has shown that he is not an employee when the accident that led to his purported admission into the hospital was occurred. Above all, the claimant has not also proved that the said amount is being claimed has been approved as required by the public service rules. In the circumstances, reliefs, the medical expenses of 25,000 naira being claimed by the claimant have not been proved, same are hereby refused. The claimant has also claimed 50 million naira as interest, but there has been no proof, as in the other cases, to establish entitlement to this, as to prove that he is entitled to recover interest on the loans which he has collected from the defendant. In the circumstances, the relief failed, same is hereby refused. From all I have been saying above, the claimant in this case has willfully failed to prove entitlement to any of the relief sought, any of the 16 reliefs being sought from the court, as the claims were clearly based on speculations and conjecture. The claims are vexatious gold digging and reefing where one did not sow. In the circumstances, they cannot be granted. The entire case of the claimant having been built on speculation fails, and same is hereby dismissed. I make no order as to cost. Parties to bear their respective costs.
As the court pleases.
Registrar, any other matter for today?
No, my lord, that's all for today,
My lord,
Thank you, counsel, for being. Yes.
my lord, we are very much grateful for the pains my lord has taken throughout this journey for 6 years. May we humbly apply that a copy of the judgment be made available so we can go through it. We are most grateful, my lord.
Don't worry, you will be given. You don't need to apply. It's your entitlement. It's
As
your
the court
entitlement.
pleases.
It will be given to you.
As the court pleases.
Yes. Yes, thank you, counsel. We have come to the end of today's. Yes. We have come to the end of today's proceeding. The administrator, you can discontinue with the sitting.